All right, let's jump right into this deep dive. Today we're exploring a really fascinating concept from your sources. It's about one family's vision for relationships, for legacy, something they call the Freedom Trust. And it's detailed in this document, the Haltom Agreement.
Right. And our mission here is really to help you understand this, well, this unique vision, but also, crucially, to look at the practical side. How does something like this actually interface with the U.S. legal system? It's about seeing the intent and the reality.
Okay, so unpack this vision for us. What's the core idea? It sounds like it's about, fostering autonomy, mutual growth, building on trust, not exploitation.
Exactly. And they use some interesting terms. The sources mention mutual guarantee bonds.
Okay, but not like Wall Street bonds.
No, not at all. These are described more like pledges, like shields for individual freedom and scaffolding for building a life together. And the key, truth is described as the essential currency.
And there's this estate of mutual edification.
Yes, and that's insightful. It's not just about money accumulating. It's about collaborative growth. Those bonds we mentioned, they're framed as nutrients feeding this estate. Things like truth, responsibility, reciprocity.
Okay, give me an example. How does that work practically in their system?
Well, the sources suggest, for instance, valuing a spouse, pausing their career for childcare. That contribution, normally non-monetary, could theoretically increase their bond value within this estate. It's an attempt to put a concrete value on those kinds of intangible but very real contributions.
Interesting. And it gets even more specific with dynamic bonds. Sources mention performance clauses and penalty triggers.
That's right. The idea is bond value could go up for positive actions, like, say, completing therapy together, hitting a shared goal. And conversely, it could decrease the penalty trigger for negative actions like, financial secrecy or exploitation.
Wow. They've even thought about separation with a jailbreak clause involving assessing this bond performance and maybe a kinship fund.
It's a very detailed relational framework. And all this is meant to be formalized in the Haltom Agreement, which they describe as a notarized statement of account designed to issue value.
Okay, and here's a critical bit from the sources. It explicitly states it's meant to be separate from secular and commercial jurisdictions, governed only by the laws of nature and of nature's God.
Yes, and that phrase right there highlights the fundamental tension we need to talk about.
The tension between this deeply spiritual blueprint and the nuts and bolts of U.S. law.
Precisely. Because when you talk about governing law, U.S. courts need something concrete. They need a codified legal jurisdiction, state law, federal law, statutes, case law. Philosophical concepts like laws of nature, however meaningful personally or spiritually, aren't something a court can use to enforce an agreement. They just aren't recognized as governing law in that sense.
So the Haltom Agreement itself, as described, what's its legal standing right now?
As it's described in the sources, as a private document outlining these principles. It likely doesn't create a legally recognized trust or issue value in a way the financial or legal system understands.
Why not? What's missing?
Well, for a legal trust, you need key pieces under recognized law. A grantor setting it up, a trustee with active duties, and critically, the trustee usually can't be the only beneficiary. You need identifiable property, actually funded into the trust. Clear beneficiaries. And a trust document operating under a recognized legal framework, like the laws of a specific state.
And the Haltom Agreement, as described, doesn't quite tick those boxes.
Based on the description, it seems to lack some of those legally defined elements and, crucially, that recognized governing law.
What about the notarization? Doesn't that make it official?
That's a common misconception. Notarization verifies that the signatures are authentic. It doesn't validate the legal substance or enforceability of the document itself.
Got it. And those mutual guarantee bonds, are they legally binding financial things?
No, not in the way the law typically understands bonds. Legal bonds are usually debt instruments, right? Quantifiable value, clear terms, enforceable in court. These mutual guarantee bonds, their value is described as tied to subjective things, relational actions, truthfulness. That's not quantifiable or transferable in a standard legal or financial sense. You can't just issue legal value based on that concept alone.
Okay, so the vision is powerful, very intentional. But the specific mechanism described in the sources seems to hit some legal roadblocks. Is there a way to bridge that gap? Can the spirit of this be achieved legally?
Yes, absolutely. The good news is the objectives providing for family, formalizing commitments, recognizing non-monetary value, those can often be achieved using existing legal structures. It's really about translation. The structure and the governing law need to align with the legal system.
So what would that look like? Option 1.
Option 1 is often a conventional, legally drafted trust, or perhaps a series of tailored contracts. This means creating a new legal document, drafted by an attorney. It would need to be funded with actual, identifiable assets, money, property, and those relational principles. They'd need careful translation into objective, measurable terms a court could understand.
Like specific financial contributions linked to defined actions?
Potentially, yes. Or clear mechanisms for how assets are managed or distributed based on measurable outcomes. And critically, it must specify a recognized U.S. jurisdiction like, this trust shall be governed by the laws of the state of X.
What about the religious angle? The sources mention Haltom Family Ministries.
That's a potential option too. If it's a legally recognized religious nonprofit organization, certain funds or agreements might operate internally under its established bylaws. But even then, the organization itself is subject to legal compliance IRS rules, state regulations for nonprofits. It's still operating within a legal framework, just a different one than a personal trust.
Makes sense. Now, the sources also brought up this idea of operating outside the box, mentioning constitutional restoration, and drew a comparison to certain theories.
Yes, the sources impartially point out that some of the language about being separate from secular jurisdictions and relying only on laws of nature bears resemblance to pseudo-legal ideas often called sovereign citizen theories. It's really important for you listening to know that U.S. courts consistently and universally reject these theories. They have no basis in established law.
So advocating for your rights happens within the system.
Exactly. Advocating for constitutional rights is vital, but it happens through established legal processes, courts, and legislation, not by declaring oneself outside of it. The comparison in the sources just underscores why getting professional legal help is so crucial here. To take that unique, powerful spiritual vision and find the right legal structure to make it work in reality.
This has been really insightful, a fascinating look at this intersection between a deeply personal vision and the practical realities of the law. The core tension is clear. You got this beautiful blueprint, but it meets the demands of a very structured legal system. The vision can potentially be realized, but the legal how really matters.
It certainly does, and perhaps it leaves you with this thought to ponder. How can our deeply personal, often non-quantifiable values, things like trust, reciprocity, mutual growth, be meaningfully acknowledged, maybe even protected, within a legal system that's primarily built for objective, measurable facts and figures?